Thank you for joining us tonight. We are offering this program through a grant provided to us by the California Commission on the Status of Women. My name is Beth Meyerhoff. I use she, her pronouns, and I'm a staff attorney with the Women and Girls Rights Project at Public Counsel.
Hi, I'm Mallory Supler-King, and I am a senior staff attorney with the Women and Girls Rights Project.
Good evening, everyone. My name is Molly Mock. I use she, her pronouns, and I'm also a staff attorney at the Women and Girls Rights Project in Public Counsel.
And I would like to thank Jess Monterey, our WGR project assistant, for all of her help tonight. Next slide, please. Public Counsel is the nation's largest provider of pro bono legal services, with over 140 staff annually working with thousands of volunteers to provide free legal services to thousands of people, small businesses, and nonprofit organizations. There are 8 projects at Public Counsel. The Women and Girls Rights Project provides free legal services for cis and transgender women, girls, and non-binary individuals. The mission of WGR is to advance economic justice by improving equity for women and girls in education and employment. We do this by working to combat systems of oppression that impact women and girls in the workplace and on campus. In the area of workplace rights, we are defending the rights of low-wage workers to a safe and fair work environment, free from exploitation, discrimination, and harassment. We provide direct services, which includes free counsel and advice, advocacy and intervention with employers and schools, representation in administrative processes and litigation. In our advocacy, we are advocating for laws and policies that advance social, racial, and gender justice and support working families. And finally, we provide education and outreach to empower workers and students with information about their rights. Next slide, please. During tonight's presentation, we will discuss workplace rights during illness, PPE and workplace safety, workplace rights of caregivers, and 2023 updates. Next slide, please. And now I'd like to turn it over to Mallory.
Thank you, Beth. Hi, this is Mallory. I'm going to start us off tonight. So first, what are your rights when you are sick as a worker? Under a California law passed in 2015, most workers are entitled to 24 hours or 3 days of paid sick leave per year. This applies to temporary, part-time, and full-time employees who have worked at least 30 days for the employer and started at least 90 days prior to the time that they take the sick leave. This time can be used for personal illness, or to see a doctor to seek a diagnosis or preventative care, or to care for a sick family member, which will be discussed in more detail a little later. Your employer can require you to accrue this time at a rate of no less than 1 hour per 30 hours worked, and you cannot be retaliated against for using this time, even if you do not give advance notice. So if you wake up one day, you're sick, you need to use a sick day, that's okay. You cannot get in trouble for using that time. If you do not have available sick time, you may be eligible for family medical leave under the California Family Rights Act. This leave is available for a serious health condition or to care for a family member with a serious health condition. It's available to full and part-time workers who have been with their employer for at least 1 year and worked at least 1,250 hours. In California, this is available to anyone whose employer has 5 or more employees, so that should be most of you. This leave is unpaid, but you may be able to get some partial wage replacement during your time off. That's something we'll talk about in the next couple slides. You should also always check your employer's policies to see if they have any policies that allow for additional time off or pay. Your job is protected during family rights leave, meaning you can't be fired while you're on leave, with very limited exceptions. If by some chance you are on this leave and you do get fired, you should always consult an attorney, because for the most part, there's no reason that you should be able to lose your job while you're on family leave. And during family medical leave, your employer must continue to provide you with healthcare benefits, so you cannot lose your insurance while you are out on this leave. Family medical leave is also available on an intermittent basis. So if you have an ongoing health condition that requires you to take time off work to see doctors, go to appointments, you can take family medical leave intermittently so that your job is protected during this time, even if you don't have other accrued paid time off. If you have not been at your employer long enough to get medical leave and you have used all of your sick time, you still may be entitled to protected time off if you are disabled by COVID or by some other illness. Disabled would mean that you're severely ill or experiencing severe symptoms that prevent you from doing your job. Under the Fair Employment and Housing Act, which is California's anti-discrimination law, you are entitled to reasonable accommodations for disability in the workplace. In some circumstances, unpaid leave may be a reasonable accommodation, and you will learn a lot more about that from Molly a little later. Next slide, please. So as many of you probably remember, starting in 2020, there were various government policies that were passed that allowed for additional paid sick leave specifically for COVID. Unfortunately, most of those policies, or all of them as they apply to Los Angeles workers, have now expired. So there is not extra sick leave for people who are sick with COVID and available at this time. Next slide. How can you get money benefits if you are sick or quarantined because you were exposed to COVID-19? We've talked about your right to leave if you are sick under the family medical leave. If you have to use this leave, there may be a state benefit program that you can apply to for partial wage replacement. If you are too sick to work or are temporarily disabled because of illness or injury, state disability insurance, or SDI, will provide benefits. This is available to all workers who pay into it, so that should be most people who are classified as employees or who are self-employed. This benefit is equally available to workers who are undocumented. SDI will provide 60 to 70% of your regular pay after a 1-week waiting period for the time that you are unable to work due to illness or injury, up to 1 year. This does require doctor certification, so if you know that you will be out of work due to illness, talk to your doctor. They should be able to help you with this process. SDI may not be available to public employees. So if you work for a government agency and are disabled by illness or injury, please look at your employee policies. If you are not too sick to work, but have to miss work for illness or related reason, such as your employer is closed due to COVID-19, or you are instructed to quarantine for an extended period, or if you are forced to leave your employment because you are sick or have caregiver responsibilities, unemployment may be able to cover partial wage replacement for the time that you are off work. Like SDI, there is a 1-week waiting period for unemployment, so only apply if you will be out of work for more than 1 week. The benefit for employment is a little lower than SDI. It's approximately 50% of your wages. And unemployment benefits are only available to employees and are unfortunately not available to undocumented workers. Unemployment may also be available if your hours are decreased for reasons related to COVID-19. If you are cut from a full schedule to a part-time schedule, for example, you can apply to unemployment to get partial wage replacement for those hours that you're no longer working. If you get sick or injured because of exposure to illness while you are at work, you may also have a claim for workers' compensation. This is a complicated area of law, so if you think that you became sick or injured at your workplace, reach out to an attorney who specializes in workers' compensation. Next slide. Can your employer force you to take paid time off, vacation time, or paid sick time? So if you are sick for a couple of days and you have paid sick time accrued, you should use that sick time. Your job is not protected during an unpaid sick day, but it is protected during a paid sick leave day. So always use that time if you have it available to you. If you take family leave, your employer cannot require that you use accrued sick time to get wages during this leave. If you do want to use accrued sick time, your employer can insist that you do this in increments of no less than 2 hours. This would come into play if, for example, you took intermittent family medical leave to see doctors. During that time, even if you only missed an hour and a half of work, if you wanted wages for that time, your employer could require you to use 2 hours of sick time. If you are on extended leave for family medical leave, your employer can require that you exhaust any accrued vacation time before you go into unpaid leave. There are some bills going through the legislature now that are trying to make it so this is not the case, so we will keep you updated. Next slide. So can your employer fire you if you can't work because you are sick or quarantined? As you remember, we just discussed different types of leave that you can take when you need to be off of work due to illness during COVID-19. The goal of these leave laws is to make sure that people who are sick are able to care for themselves without worrying about losing their job. Under the Family Medical Leave or California's Family Rights Act, your job is protected and you cannot be fired while you are on leave. If you have requested an accommodation for a disability under the Fair Employment and Housing Act or the Federal Americans with Disabilities Act, your job has slightly fewer protections, but you cannot be fired because of this accommodation or because you took leave. Next slide, please. So what if your employer discriminates or retaliates against you for taking sick time or for using this leave? If you are fired while you are on one of these leaves or using sick time, or if you were treated differently when you return to work after one of these leaves, such as having your job duties changed or having mean comments directed at you, this is retaliation and it is illegal. If this happens, you have the right to talk to a lawyer, file a complaint with a government agency, and even bring a lawsuit against your employer. If you think that you are being treated differently after requesting time off due to being sick with COVID-19 or any other illness, you should call Public Counsel's advice hotline. You can sign up for a slot on our website, and Jess will drop a link to that sign up right now. We are here to give advice, so always reach out to a lawyer and make sure that you understand your rights and that you get help if you need it to enforce them. I'm about to finish up. Please remember that if you have any questions, please put them in the Q&A box and we'll answer them at the end of the presentation. And now I will pass it over to Beth.
Thank you. Next slide, please. Let's talk about an example and apply some of the concepts that you have just learned about. Elena contracted COVID and became very sick. She was in the hospital and under a doctor's care for 3 weeks. In this example, Elena is very sick, so sick that she cannot work. A few other details as you think about this example. Elena has been working for her employer for 2 years, and she works for a company with 25 employees. Do we think Elena can be paid? And is her job protected while she is off of work? I'll give everyone a moment to think about this. Next slide, please. Can Elena be paid while she is sick and off of work? One option is that Elena could use her sick leave. Remember that employees must have worked at least 30 days in a year and start at work at least 90 days earlier than using the sick leave. Since Elena has been with her employer for over 2 years, she may have accrued sick leave, but her employer cannot require her to use sick leave. Another option is for Elena to use her vacation time. The employer can require you to use vacation time at the beginning of unpaid leaves. Since Elena's illness has continued for several weeks, state disability insurance, or SDI, is an option. SDI is available to all workers who paid into disability. Remember, there is a 1-week waiting period, and most workers will receive 60 to 70% of their regular pay and benefits. Unemployment insurance could also be an option if Elena is forced to leave work. Again, there's also a 1-week waiting period. Elena's job could be protected under the California Family Rights Act. Because Elena is so sick she cannot work, that could constitute a serious health condition. Elena could take up to 12 weeks unpaid leave under CFRA. Next slide, please. And now I'll turn it over to Molly.
Thank you, Beth. So now we're going to talk about what your rights are for workplace safety. You have a right to wear a mask at work. Employers must allow employees to wear face coverings, masks, or other personal protective equipment, also known as PPE, if they voluntarily choose to do so, unless it would create a safety hazard when carrying out their job duties. A safety hazard could be something interfering with a safe operation of equipment. Essentially, your employer would have to show that if you wear a mask, it would be unsafe to do so given your specific job duties. The right to wear a mask at work can also be considered a reasonable accommodation as well under certain circumstances. And we'll get into what a reasonable accommodation is and when they may be necessary on the next slide. Your employer could also require you to wear personal protective equipment. Employers can have policies that are more protective than required under the law. This means that even if the law does not require you to wear a mask, your employer can require you to wear a mask. However, reasonable accommodations may be made for workers who cannot wear face coverings. Some examples of situations like that would be if you have a medical or mental health condition or disability that would prevent you from wearing a mask. Another example would be for those who are hearing impaired or workers who are communicating with hearing impaired persons, or when a worker has to perform specific tasks that cannot be performed while wearing a mask. And if your worker does, or if your employer does require you to wear personal protective equipment while you are working, they must provide it for you. Next slide, please. What if you can't get a vaccine? Your employer, so first off, your employer can require you to obtain a vaccine. However, you could be entitled to a reasonable accommodation. A reasonable accommodation request primarily falls under two different legal concepts, and we're going to go into both of them in particular. The first one is if you have a disability under the law, or if you have a sincerely held religious belief that would prevent you from getting the vaccine. So first, if you have a disability under the law, under the Americans with Disabilities Act and the California Fair Employment and Housing Act, also known as FEHA, you can be entitled to a reasonable accommodation based on a disability. And an employer must provide a reasonable accommodation to an individual with a disability unless it would pose an undue hardship on the employer. So what are some scenarios that could come up related to a COVID-19 situation in particular? The first example is a disability places an individual at high risk of severe illness if they were to contract COVID-19. Examples of this are immunocompromised persons, people who have diabetes, heart conditions, cancer, kidney diseases. All of these are just some examples of that. Another example is a disability that is caused or exacerbated by the pandemic, like an anxiety disorder, or a disability caused or exacerbated by having had COVID-19. And finally, another example would be a disability. The disability itself is the reason the employee cannot comply with a vaccination, testing, maxing, or other employer infection control requirements. An employer can select any effective accommodation. I will note here, however, that the law does not require an accommodation of an employee based on association with someone who has a disability. For example, if you live with or are a caregiver to someone who is immunocompromised, your employer is not required under the law to give you a reasonable accommodation. However, the Americans with Disabilities Act or the Fair Employment and Housing Act does not prevent an employer from going above and beyond the requirements to provide flexibilities to employees due to a family member's disability. All of that is to say, while they are not required in that situation, it doesn't hurt to ask. Moving on to the second legal concept, to request a reasonable accommodation if you have a sincerely held religious belief that would prevent you from getting the vaccine. Under Title VII and the California Fair Employment and Housing Act, you could request reasonable accommodation based on a sincerely held religious belief, and an employer must provide that reasonable accommodation from a requirement that conflicts with an employee's sincerely held religious beliefs, practices, or observances, unless, again, it creates an undue hardship for the employer. An employer who has an objective basis for questioning the religious nature or the sincerity of the belief may ask additional questions. I will note here that social, political, or economic views are not protected under the law as a sincerely held religious belief. The employer should engage in an interactive process with you when you request a reasonable accommodation, and this could involve several conversations with you. And let's talk about some common accommodations in lieu of getting the vaccine. Some accommodations could be wearing a face mask, a workstation that's modified or relocated for physical distancing, periodic COVID-19 testing if you are physically entering the workspace, modified shifts or hours, working from home, transfer or reassignment, or a combination of any of these. And finally, a reasonable accommodation should be granted by your employer unless it is not possible for the employer to accommodate you and conduct business as usual, or if it is cost prohibitive for the employer. And with that, I will pass it back to Beth.
Thanks, Molly. Next slide, please. What if an employee has to care for someone else who is sick? Many workers are also caregivers for other people. California law allows employees to designate some of their sick days for what is called kin care leave, also known as protective sick leave law. Kin care time is time off of work to care for a family member. An employee can use up to half of sick leave for specific family members, and it is for the care for a family member who is ill or needs a medical diagnosis, treatment, or preventative care. A family member for purposes of kin care is defined to include an employee's child, parent or guardian, spouse or registered domestic partner, grandchild, grandparent, and sibling. Notably, this does not include in-laws. Paid family leave is available for workers who pay into the state disability insurance SDI program. Paid family leave gives employees up to 8 weeks of wage replacement while caring for a family member. In addition to caring for a seriously ill family member, paid family leave provides benefit payments to people who need to take time off work to bond with a new child or participate in a qualifying event because of a family member's military deployment. Paid family leave provides benefit payments but not job protection. Your job may be protected by other laws, such as the Family and Medical Leave Act, FMLA, or the California Family Rights Act. The California Family Rights Act provides job protection for up to 12 weeks. As discussed earlier, it can be used to care for an employee's own serious health condition, and it can also be used for the serious health condition of a family member. As a reminder, an employer must have 5 or more employees, and the employee must have worked a minimum of 1,250 hours and had 1 year on the job. It is unpaid. Starting in 2023, an employee can name a designated person. You may now take 12 weeks of unpaid leave or use paid sick leave to care for an extended or chosen family. An extended or chosen family is defined as any individual related by blood or whose association with the employee is the equivalent of a family relationship. To use these benefits, you may request leave directly from your employer. Next slide, please. Can my employer fire me if I cannot work because I need to take care of a sick family member? The law protects you while you're using these leaves. The California Healthy Workplaces, Healthy Families Act, this refers to sick leave, and this act ensures that most employers provide employees with paid sick leave. The law also protects you if you are using the California Family Rights Act leave, the details of which we have just discussed. If you are fired or otherwise penalized for using these leaves, please contact public counsel. Next slide, please. School closures can happen in a variety of situations in addition to the school closures we saw during the pandemic. For example, some parts of our state are susceptible to wildfires, which can require school closures. Or recently, the rain and snow might affect its school opening, or sometimes there could be a disease outbreak. The Family School Partnership Act is a California law that allows parents or people who are guardians, step-parents, foster parents, or grandparents to take time off of work to participate in their children's school or childcare activities. The law first took effect in 1995 and was expanded to add licensed child daycare facilities to the kindergarten through grade 12 levels included in the original legislation. Work sites need to have 25 or more employees, and it is generally unpaid unless your employer has an alternate policy in place. Some other options employees can explore are paid sick leave, as well as unemployment insurance benefits if you become unemployed. You may be eligible for regular unemployment insurance if your child's school is closed and you need to miss or end up leaving work to care for them. Next slide, please. Rebecca has a child in daycare. Her child was very sick for a week, then the daycare closed multiple times over the next month. Can Rebecca be paid while she is out caring for her child for the week? Can Rebecca be paid while the school is closed? Is Rebecca's job protected? All right. Next slide, please. The person Rebecca is caring for is her child, so that qualifies as a family member. Rebecca can use her kin care leave and use up to half of sick leave available in 1 year for a specific family member. Since her daughter is very sick, Rebecca is caring for a family member who is ill or needs medical diagnosis, treatment, or preventative care. Rebecca can also use her paid family leave to care for a seriously ill family member, assuming she paid into SDI during the base period. For the multiple daycare closures, Rebecca can request to use the Family School Partnership Act to take time off from work to participate in her child's school or childcare activities. And depending on her employer's policy, that may or may not be paid. And finally, under the CFRA, Rebecca's job would be protected and she could take up to 12 weeks of unpaid leave while taking care of her seriously ill family member. During the long school closures, Rebecca should work with her employer to access her leave options. Next slide, please. All workers who have paid into the Employment Development Department, or EDD, are eligible for benefits regardless of their documentation status. Employees would be having money withheld from their checks each week or month. Employees are eligible for SDI, the state disability insurance, and PFL, or paid family leave. The EDD operates both of these programs. One way to think about this is PFL is like SDI, but for caregivers. SDI is for workers unable to perform their usual work because of their own non-workplace injury or illness. And as we mentioned, there was a 7-day unpaid waiting time. And the California paid family leave is 8 weeks within a 12-month period. There is no waiting period. Employees apply at the EDD office, either online or by requesting a paper form. The online version requires a Social Security number. Undocumented workers are not eligible for unemployment insurance. Next slide, please.
Let's now turn to some updates to the law that have happened for 2023. As discussed previously, but worth highlighting again, supplemental paid sick leave for COVID-19 has expired on each level: federal, California state, and the city of Los Angeles. So supplemental paid sick leave is no longer available. Bereavement leave: workers who are employed for at least 30 days with employers that have at least 5 employees are eligible to take up to 5 days of unpaid but job protected leave for the bereavement of a child, spouse, parent, sibling, grandparent, grandchild, domestic partner, or parent-in-law. The Chosen Family Bill extended job protected caregiver leave for a designated person. So if you want to take Chosen Family leave, this person that you are caring for does not have to be a blood relative or spouse under this new law. However, it is unpaid. The paid family leave does not include the chosen family definition. However, there is proposed legislation that is being considered by the California State Legislature this year that could expand the definition of family within the paid family leave law to include chosen family. So we'll keep an eye on that and keep you updated. Wage transparency: employers with 15 or more employees, including part-time and full-time employees, must include pay scale information in all job postings. Pay scale information means the salary or hourly wage range that the employer reasonably expects to pay for the open position. Covered employers must include the salary or hourly wage in all job postings. Additionally, all employers must provide pay scale information when it is requested. Employers with more than 100 employees must collect demographic data and file annual pay data reports. Next slide, please. And looking ahead to 2025, low-wage workers will be able to receive up to 90% of their regular pay when they are disabled from working, bonding with a new child, or caring for a seriously ill family member through paid family leave or state disability insurance. Currently, the law is you only get up to 60 to 70% of regular pay. So in 2025, it will bump up to 90%. And to qualify for this, you must contribute to paid family leave and state disability insurance. And most California workers contribute to both of these things. Low-wage workers would receive up to 90% for the first 16 weeks of state disability insurance and all 9 weeks of paid family leave. Next slide, please. So we are going to get to the question and answer portion of our presentation shortly. So if you are sitting on any burning questions, please drop them in the Q&A box and we will try to get to all of them. In the meantime, I wanted to let you know about an upcoming event that we have in about a month on April 4th at 5:30 p.m. in the same format as this, a Zoom webinar in English that is going to be translated in Spanish. We will give a presentation on pregnancy and parenting rights at work and on campus. And Jess will drop a link to sign up for that in the chat if you're interested in joining us. Next slide, please. I also wanted to highlight our weekly workplace rights clinic. Jess will also drop a link to this sign up in the chat, or you can find it through Public Counsel's website. This workplace rights clinic takes place every Wednesday, and you can sign up for a time to speak to one of our attorneys between 4 p.m. and 7 p.m. If we don't get to your questions today, or you'd like to speak to us further about an issue you might be having at work, we would encourage you to sign up for an appointment and speak with us. Now, last thing before we jump to the Q&A, the question and answer, I wanted to note that when all of you close this Zoom, a short survey will pop up, and we would really appreciate if you take a couple minutes just to fill that out for us. And now to some of the questions that you all have asked throughout the presentation. If you are sick with COVID-19 between December 31st, 2022 and February 15th, 2023, are you entitled to supplemental COVID sick pay through the local ordinances?
So the answer to that is if you worked for an employer that falls within the local ordinance, during that time, you were entitled to supplemental sick pay. And if you did not get paid the supplemental sick pay that you were entitled to, you still have plenty of time to bring a claim to collect the pay that you were owed. One thing to note is that the Los Angeles ordinance, which is the one that was in place until February 15th, only covered employers with 500 or more employees. So it is for very large employers. That's in big contrast with the California supplemental paid sick leave that expired earlier, which covered all employers with 25 or more employees. So if you got supplemental paid sick leave earlier, but were told you weren't entitled to it in 2023, you should look at the size of your employer and see if that's a factor. If you do think you were denied supplemental paid sick leave that you were entitled to, please feel free to contact our clinic and we can talk you through what your options are.
Thank you, Valerie. Second question, how and to who do workers file an administrative complaint if they face retaliation? What information is needed to file the complaint, and how long does the resolution process take?
So that's a great question. It's a little complicated for the answer because it depends on what you're being retaliated against for. If you are being retaliated against for using the paid sick time that you're entitled to under the law, then that would be a complaint that you would file with the labor commissioner. And that is easy to find. Google labor commissioner complaint. That's easy to file online. You can also file that through the mail if you would prefer. If you are retaliated against for taking family rights leave under FMLA or the California Family Rights Act, or if you are retaliated against for requesting an accommodation under the ADA or the Fair Employment and Housing Act, that would be a complaint with the Civil Rights Department, which is the new name for the Fair Employment or Department of Fair Employment and Housing. Both of these processes require as much information as you can provide about your regular hours, the dates that you took time off, the reason for the time off, and any other details you can provide will be helpful to them. They all do also require identifying information about yourself and about your employer. These processes can be long. For the Civil Rights Department, I think an investigation and determination generally takes around 1 year. And for the Labor Commissioner, I think they're running a little longer than that right now. We are definitely advocating to make these processes a little faster, but I think that's the current timeline.
And in your offices, do they speak Spanish? The majority of people in the community speak only their original languages. Some of us don't speak Spanish.
Yes, so the Women and Girls Rights team has a couple of Spanish speakers on it. So we are able to internally translate for clients and callers who are Spanish speakers. We also do work with Language Line, which is a support program where they provide interpreters for a huge number of languages, including some Indigenous language support. So if you need legal assistance and you speak a language other than Spanish or English, please just let us know when you sign up for an appointment, and we will make sure that we have the language access set up so that we can assist you.
Great. Can you receive Family Medical Leave Act and state disability insurance at the same time?
This is a great question. So yes, and you should. If you are out of work for a personal health condition, you would take the leave, the extended leave that is job protected under Family Medical Leave, or in California, the California Family Rights Act. That's the law that gives you the job protection and the right to take the leave from work. SDI is the program that you would apply to in order to get wage replacement while you were on family medical leave. So you would take the leave under FMLA and then apply to SDI in order to get monetary benefits from the government to help make sure that you have some income coming in while you're on that leave from your work. So they're complementary programs.
Can the participants get a copy of the presentation?
That's a great question. I think that we probably can do that. If I'm being told yes, we can do that. So
stay tuned after the
presentation. Stay tuned. We will find a way to get that to you after the presentation.
And this is the last question we have in our question and answer, and we're coming towards the end of our time. So the last question will be, are there any legal supports for workers in settings where COVID safety precautions are not being followed?
Yes, absolutely. So in terms of administrative options, workers have the right to file a complaint with OSHA, which is the safety and health and workplace health and safety department. Basically, if you are in a workplace where you feel that you are unsafe, you should seek legal advice as to what rights and remedies you may be able to pursue. Again, that would be a great option to call our clinic, make an appointment, and we can work with you to talk you through what options may be available to you. You always have a right to be in a workplace where you feel safe and where you are not at risk of health or injury.
Excellent. Thank you so much, Mallory. That concludes our question and answer portion. Another reminder, please fill out our survey. At the end, it should take you just a couple of minutes. If you have any follow-up questions or you would like to discuss any workplace issue further with one of our attorneys, please sign up for our Wednesday Workplace Rights Clinic. We are happy to discuss those issues with you. And I just wanted to thank all of you who came and participated today. I also want to thank our wonderful interpreters, the Women and Girls Rights team and Public Counsel's communication team for all the efforts put into this event. We would also like to thank again the California Commission on the Status of Women and Girls for their support and funding to make this presentation happen. And so we'll end a little early tonight and have a wonderful evening, everyone.